Got two stories for you. One that might make your blood boil a little bit, but one that you might find a little bit hopeful. So what's the first one? Well, when do you have to prove your innocence? Well, according to both the English and Welsh courts and the European Court of Human Rights, when you have been falsely convicted and you want compensation. So let me explain. Let's say that you or somebody you know is falsely convicted, but eventually that comes to light and you are released, you succeed on an appeal or something like that. Do you get compensation? Well, theoretically, yes. There are actually two schemes. There's a statutory scheme and a discretionary scheme, but they more or less work the same way. But how do you actually get the money? Well, under English law, you have to actually prove that you were demonstrably, factually innocent. It's not merely enough that, say, the Court of Appeal says this was an unsafe conviction, you should never have been convicted. Currently, you have to put positive evidence in and prove so that the court is sure, in other words, beyond reasonable doubt, that you were in fact innocent. And even then, actually, they actually they used to knock your board and lodgings off. So they'd give you the compensation and say, yeah, but you were banged up for 19 years. So you owe us 19 years board and lodgings. So they'd actually deduct that. After that recent case with a guy who was banged up for 19 years, they have actually now changed that and said, okay, you just get the full amount. But it's very rare to even qualify in the first place because of this proving your innocence bit. So some people who'd been subject to this, they took a case to the European Court of Human Rights and they said, look, this scheme is completely unfair, especially where a lot of other countries have a thing which is, yeah, okay, if you were banged up and you are subsequently successful on appeal, well, you get the compensation. So they said the way that we do it in England and Wales is unfair. It's a breach of our human rights. It's unfair treatment. However, in a decision 12-5, the ECHR said, no, we're not going to interfere with that. It's up to England and Wales to decide their own procedures. So there you are. So the current system is considered to be fair. But that gives me a chance to talk about the ECHR generally, because it's often misunderstood. So what exactly is it? Rather confusingly, there's two ECHRs. There's the European Convention on Human Rights, and there's the European Court of Human Rights. Sometimes lawyers will actually spell that ECTHR, just to make it clear that we're talking about the court rather than the convention. What does the convention do? It sets out a series of articles. So Article 2, for instance, is the right to life. Everybody has the right to life. But there are exceptions. I mean, even under the ECHR, there's an exception for if you are sentenced to death by a competent tribunal. That's an exception. If you are fleeing from the police or resisting arrest, that also counts. And then there's all general stuff like, the use of force to prevent harm to yourself or other people. And remember, generally speaking, the articles, they only apply to the state. They have what we call vertical effect. In other words, you can only bring a claim against the state. Sometimes, though, we have what we call horizontal effect. So, say for instance, there's a body that the state controls, and that is being unfair. Say for instance, you want to sue a school for breaching your human rights, for not letting you wear religious, apparel or something like that. Well, you're not suing the state particularly, but schools are under the auspices of the state, so therefore you can actually bring a claim like that. You can also bring a claim, say for instance you were just somewhere where you were being persecuted, not by the state, but you were in a minority group that got a lot of persecution and the state was turning a blind eye to it. You could bring a claim there and the state will say, well, it's nothing to do with us, we're not doing it. But you have to, as a state, sort of provide a safe sort of, environment for people. How did the ECHR come about? It's after World War II, actually. Post World War II, people looked and said, how could civilized countries do these sorts of things, especially all the atrocities, in Germany and the occupied countries with all the deportations and the death camp. So Winston Churchill said, right, we are going to impose, well, we still have a bit of the remnants of empire, we're going to impose British values on Europe. So a bunch of lawyers we got together and they said, draft us a convention based on English rights and English law that everybody who signs up to this, which we're going to pretty much force them to do, has to abide by. So the thing to remember is the ECHR has nothing to do with the EU, the European Union. It predates it by many decades. And it's not just the EU countries that signed up to it. Russia, for instance, used to be a member, used to sign up to it. They've pulled out now for obvious reasons, because they don't particularly, like like being held to account. But how did you enforce this? Well, interestingly, we also set up a court in Strasbourg, the European Court of Human Rights, where people, if they were unsatisfied with how their local domestic state courts were dealing things, they could take it to the European Court of Human Rights, and the European Court could rule on cases and say to the state government, you need to do something about this. Now actually, theoretically, the states can just ignore that. I mean, we did that. The ECHR said prisoners should be allowed to vote, and we said, well, we disagree with that, so nice decision, but we're just going to ignore it. It's almost a bit sovereign citizen thing. It's like, we didn't consent to this, so we're not going to abide by it. But it used to be that the ECHR wasn't incorporated into English law. I mean, the argument always was, we don't need to incorporate it because these are just our values anyway. So the courts, theoretically, had these values anyway, but you could actually, if you were unsatisfied with what happened in England and Wales, you could go off and you could go and say, we're off to Strasbourg and we're going to see what they do. In 1998, the Human Rights Act was introduced, and that incorporated the European Convention on Human Rights into domestic law. So you could run all these theoretical sort of, high-end jurisprudence type arguments in the English courts. Although the ECHR still exists as a sort of final appeal court. So if you have exhausted your remedies, you've gone all the way up to the Supreme Court and they say, no, we find this, you can say, well, we're not happy with that, I'm going to go to the ECHR. But the ECHR tends not to overrule state courts. They'll go, well, because we have this idea of what's called the margin of appreciation. So although there's a set of common values, how those values are actually put into place on an individual state level is left very much up to the countries. So the mere fact that in some countries, like I say, they have a different regime where if you are acquitted, you get the compensation. They said, no, the margin of appreciation, we're not going to interfere with how they do things in England and Wales. You can also have what's called derogations from the articles. That's where you say, for various reasons, we are going to ignore some of these articles. So your right to life, your right to a fair trial, your right to not be subjected to degrading and treatment, torture, that sort of thing. We did that in the Troubles with the Irish situation. We said, look, because of the situation over there, things are pretty desperate, so it might be we have to deny people the right to legal representation. We might say you can't have a lawyer. I mean, there was detention without trial. There was internment. So they basically locked up people they suspected might be involved with, the provos, or might be involved in sort of supporting the Republicans, and they just locked them all up, and that was a derogation. You can also have a declaration of incompatibility. Sometimes the courts will do that. They will say, we find this new legislation, as a matter of fact, it does not comply with the ECHR. So we will issue a declaration of incompatibility just to say we don't think it fits. But ministers themselves can do that. They can preemptively say, we accept this is going to breach the ECHR. They did that with the Rwanda bill. So at the end of it, there was a thing from the minister, because they're supposed to sign off and say, we think this legislation is ECHR compatible. But in that particular case, they said, they signed off and said, we accept that we don't think this is ECHR compatible. So remember that when people are saying we need to pull out the ECHR, well, actually, you can ignore it if it's convenient. And that's quite often what people do. But yeah, so that's an overview of the ECHR, both of them, the convention and the court. What's the other bit of news? Well, the SRA, the Solicitors Regulation Authority, have issued a Part 8 claim demanding that the Post Office and their lawyers hand over all the materials that they used post-conviction with some of these Post Office sub-postmasters. So remember, some of them were acquitted on appeal. But because of the conduct of the lawyers, especially with things like not disclosing things properly, the SRA, because remember I was complaining about this because they were saying, oh, we're going to wait till the end of the inquiry before we take any action. Well, it seems now they have got off their asses a little bit, and they have issued a Part 8 claim, and that basically forces the Post Office to hand over all the material in relation to about 30 cases. They've done it on the basis that we just need this information for our regulatory procedures, because as the role of the regulator, we need this. And they've given a guarantee saying we will only use this for regulatory stuff, because they've had to hand over everything, including stuff that would normally be legally privileged. There is a procedure in there where they've said if you need to go beyond this, then you think you need to use this material beyond just your regulatory powers, then you have to let people know so they can make representations. But what's a Part 8 claim? When you hear the word part, that's because the civil procedure rules are divided into parts. I remember, I'm old enough, I learnt under the old rules of the Supreme Court, where it was all, order something. Everything was ordered, like Order 14.2 and stuff. But it used to be, in olden days, before the CPR came in, or the Wolf reforms as I still call them, because I went to bar school, I learned everything under the old regime the year before they changed it. So it was like, congratulations, you've passed, everything we've told you is now obsolete. But it used to be there were two ways of starting claims. You could do it by writ, or you could do it by originating summons. A writ was when you just wanted to sue somebody generally. I wish to issue a claim against somebody, I'm going to sue them for breach of contract, defamation, breach of trust, personal injury, negligence, anything like that. You issued by way of writ. But there were certain procedures where you say, well, I need something doing, but it's not going to lead to a full trial. Say, for instance, I want to sue somebody, there's no argument about the facts of the case, but we're not sure how the law applies. Well, then you could do it by way of originating summons. So you'd say to the court, we don't need to decide any issues of fact. We're not going to call any witnesses or have cross-examination. We'll just put in statements saying this is the agreed facts. Can you rule on what the outcome should be? Now, the idea of the CPR was to simplify this, and they said, no, we should do it. It should all be just on one claim form. It's got to be a streamlined system. There's no justification for having two separate systems. And then when they did that, they came out and said, right, if you want to issue regular claims, it's Part 7, because that's Part 7 of the CPR. But if you want to issue for a not regular claim, like, for instance, to decide an issue of law where the facts aren't in dispute, use a Part 8 claim form. So it's like, well, hang on, that's just the old writs and originating summons, just with a rebrand. So I can't quite see the point of it. Sometimes you'll actually issue on the wrong one. You'll bring what you think is a Part 8 claim, and then it'll turn out the facts are all in dispute. Usually the court then will say, we'll just treat it as a Part 7 claim. But in this particular case, they've issued the Part 8 claim because they're saying, we're not asking you to decide any matters of fact or anything like that. We're just asking you to order the delivery up of these documents. So it'll be very interesting to see what they do with them. I mean, because of all the confidentiality elements to it, especially if some of this is privileged material, we probably won't find out for quite a long time. But it does seem now that the SRA is indeed about to take some action. So there you go. I'll do more on that as more comes to light, if it does. There's quite a lot of post office stuff I can talk about. But there you go. Anyway, as always, hope you found that vaguely useful, vaguely interesting. Like, subscribe, share, all that sort of thing. Keep forgetting to say that. Where am I today? I'm at a place called St Clement. The church I was in the other day is just over there, but I'm just sat by the riverside, although I mistimed it because I wanted to come here at high water, but I totally got my times exactly out of phase, so I've come here at low water instead. Still very pretty though. And thank you to all the people who pointed out that sparrow was in fact a robin.